do.
Yes,
Of the last couple of days, we've been convicted more so than previously. Conversations that are uncomfortable.
Yes.
To have conversations that many would not want to have because, okay, so where are we going to go?
Yes.
And then to be comfortable enough to say that at the end of the conversation or at the place where the conversation transitions, it is okay for us to say we are not so sure what direction we are taking. But by the very fact that we are having the conversations means that we are vested and trying to make sure that a solution at some point is reached.
That's correct.
Or that we can continue to survive within the space that we are in.
That's correct.
So even as we do that, Dennis will tell you what country we are in this week. And we would like to hear your interpretation of today's proverb.
Yeah, so today we are in South Africa. This country is Eswatini. It is a monarchy. And one thing that stands out is the Inchwala ceremony. Now, this is a sacred kinship ritual held around December or January, where the country gets to celebrate and harvest and reaffirming the king's spiritual role. It's exclusive to Eswatini. You can't get it anywhere else.
Yes.
And our proverb today: the antelope that is constantly moving will fall in a pit.
Yes.
The antelope that is constantly moving will fall in a pit. What do you make of that?
I make it of one thing that it has several interpretations in my view. That an antelope that is constantly moving might be trying to run away from a prey, and therefore what it's focused on is saving its life, and therefore where it is stepping or jumping on matters not as more than saving its life. That can be one interpretation. The other interpretation could also be equated to the one that we say that a rolling stone gathers no moss, in the sense that it's likely to fall into a pit because it may be reckless because it's perhaps focusing on something else. And therefore to say that I would equate it to this current regime, that the regime has fallen into a serious pit because they are not able to sit down and recollect themselves, to reevaluate themselves, to plan. That's why you're falling into a ditch or into a pit, because you're basically not engaging your faculties into what you are doing. And therefore, if the antelope itself is running helter-skelter, it will not have the opportunity of composing itself and looking at why it's limping too.
Yeah.
Great.
Yeah.
Well put.
Yeah.
That's it. So we were guests to this arena.
Yes.
On Tuesday.
Yeah.
That doesn't mean that's when the quote unquote party started.
Yes.
That we saw. And it's good that you're here because you can then guide us. In terms of sub judice and all of this.
Yes.
We heard that she had been arrested.
Yes.
Rose Njeri. And the reasons as to why she was arrested is because of this website that she had created.
That's correct.
In terms of giving information about the finance bill and allowing members of the public who then read and resonated or did not resonate with the information that she had put out there, which, by the way, it's information that is in the public domain. It was just broken down for people to understand.
Yes.
She was arrested and then charged with the contravention of the Cybercrime, and it's a very long thing, something Technology Act.
Yes.
Right? Contravention of the same.
That's correct.
Okay. After looking for her for 90 hours, just over 3 days, she was finally presented in court on Tuesday.
Yes.
With, I think, a historic number of lawyers for an individual in this case. And she declined to take plea, of course, on the advice of her lawyers.
Yes.
And then she was released, was it 100,000 shillings?
Yes.
And then called back for mention on the 20th of June.
Yes.
Many legal minds have put their thoughts and opinions towards this and said, you know what, the judicial officer in that position actually should have just looked at this thing and said, this is a waste of time. It's a travesty of justice. Why don't we just let her go home and forget about all this thing and stop wasting the court's time and resources? Because it was frivolous at best. From a legal point of view, not taking any sides per se, what does this actually look like to you?
It's very unfortunate that the country finds itself in this situation where dissident voices must be silenced at all cost. What we took in that matter, and I must thank the lawyers who turned up in defense of this real girl, being led by His Excellency Dr. Kalonzo Musyoka, the Chief Justice Emeritus, David Maraga. We also had the Senator for Makueni, Senator Maanzo, and many others. It was also the President of LSK Emeritus, the Uri Eric. We also had Kibe Mungai and many others who also turned up. We also had the LSK represented by Council Mango. And all what we were doing is to make sure that we defend what we have already gained. And what we were defending is the freedom of expression. I take it that the country is in a situation whereby they do not want to hear any other dissident voice. They only want to hear the voices of praises. Because the reason why the real girl was charged is because she actually did what the Constitution required of her.
Okay.
That in this current era and this constitutional dispensation, the involvement of the people in legislative process is a fundamental principle in our constitutional democracy. In the sense that the backlog of our constitutional dispensation and the democratic dispensation, the central aspect of it is the people. And that's why we begin by saying that power belongs to the people and that they shall exercise their sovereignty in accordance with the Constitution. So the Constitution has created the mechanism of exercising this sovereignty. Among them is a mechanism of public participation. And this mechanism of public participation was designed to make sure that the people have a say in the manner and in the mode and means in which they are governed. And that they do not just surrender their power holistically to an institution that at one particular time may become arbitrary and the people may not have the opportunity of checking on the arbitrariness of that particular institution. And that is why we created residual powers and reserved them for the people.
Okay.
That the people must be involved in the processes that the government of Kenya at that particular time is engaged in. So the website was created for enhancing and operationalizing that constitutional dictate of the participation of the people. So they created a website, they created emails, they published those emails, and of course the purpose of the publication of those emails to the public was to invite the members of the public to react.
To be in contact with them.
And to be in contact with them.
Okay.
And it was the only feedback mechanism that was offered by Parliament. So when Rose responded to the invitation in the manner in which she responded, because there was no directions as to how one ought to respond. They never created barriers or restrained individuals on how you should respond to the invitation. So she responded in that manner and also facilitated other individuals who wanted to participate to have an interaction with the Parliament. So the question therefore was, if she's responding to an invitation and there's a prima facie presumption that the person who has published this website, Parliament, wants to have an interaction with the people of Kenya, how has she then committed an offense?
Okay.
And that's a fundamental issue, and that's why we refused and objected to her taking plea.
Because you can't say that you're guilty or not guilty on something for which there is no offense that has been
something
caused.
that the law requires you to do.
Okay.
something that the Constitution requires you to do. You have responded in that manner. So you cannot then therefore say that she has created interference. But we must read this thing beyond the legal jargons. We must read this thing beyond the charge sheet and beyond the innocent girl. The innocent girl represents a bigger cross-section of the society that is discontented with what is happening in this country. Number two, she represents the group that was out in the streets on the 25th of June 2024. And remember, what took us to the street as at that time was the same reason that Rose was responding to. So in a manner to create fear, in a manner to create intimidation, in a manner to silence the voices of the individuals who may be discontented with the current finance bill, they had to arrest her so that any other person thinking that you can still oppose the finance bill, you can be retributed. So the reason for arresting her and keeping her in custody for 4 days, when the Constitution provides a right to bail or bond, was to ensure that the government breaks our bonds, so that they silence any other dissident voice, to act as a deterrence mechanism and to inhibit any other person who may be having a view of that nature.
Ndegwa, we talk about dissident voices, but when Njeri was arrested on the basis that she published a website, right?
Yes, that's correct.
And in that website that she published, she never told you how to express yourself.
How to respond.
You could either say, I support the bill,
yes,
or I don't. Pretty much public participation that the government needs to ensure that Kenyans are party to. If you remember Finance Bill 2024, Kenyans pretty much said, we expressed ourselves on this finance bill.
Yes.
Refused to pick up our responses.
That's correct, yes.
But she's made it easier for the government, pretty much doing the government's job. When we talk about the emails that are there for public officers, these are .go.ke.
Yes.
Public property owned by Kenyans.
Yes.
How is it then an offense to send an email to a public official?
And you know, that's a question that I actually put to the court, whether there is actually an offense. Remember, the Constitution that we enacted had contemplated such kind of scenarios and occurrences. And under Article 50, it is provided by the Constitution that no one shall be convicted of an offense if the offense was not defined in law as at the time of the alleged commission or omission.
You need to say that again.
Yes.
The Constitution under Article 50, Clause 2, Paragraph O, provides that no one shall be convicted of an offense if the offense was not defined or known in law at the time of the alleged occurrence, omission, or commission.
Okay.
In Latin is a common law doctrine we call the doctrine of nullium crimen sine lege. You cannot be punished of an offense if the offense has not been defined by the law.
Okay, so that is the reason why then she was advised, or it was said that she was not going to take.
You cannot take plea because the offense that you're asking me to respond to does not exist in our law books.
So why is, and I need you to explain on this particular excuse me, Wakili. If we're saying that this particular offense, there was a charge sheet, right? And this particular offense is that there was contravention to this particular Cybercrime Act.
Yes.
And that what she did was that ask people to send, and we did see that there was sending of communication to these public emails that were provided.
Yes.
Are we saying that this charge or this particular offense is not provided for, is not described in, is not defined by law in any way, shape, or form?
If you may allow me, just for purposes of aiding our listeners to understand what we are saying, I refer to that particular section that Rose was charged. This will not be sub judice because the law is law, and we have to read as it is written by Parliament. It says section 16 of the Cyber Computer Misuse and Cybercrime Act. A person who intentionally and without authorization does any act which causes unauthorized interference to a computer system, program, or data commits an offense and is liable on conviction to a fine not exceeding 10 million or to imprisonment for a term not exceeding 5 years. So what are the ingredients of this offense? One, intentional and without authorization does any act which causes unauthorized interference. So the fundamental ingredient here is one, the intention. Number two, without authorization. But let's go now to subsection 2. It says, for purpose of this section, an interference is unauthorized if the person whose act causes the interference is not entitled to cause that interference. So for you to understand whether this amount to interference, this is a test, is a person who is alleged to have caused that interference authorized or entitled to cause interference? The answer to that one is yes, because Njeri is a citizen of the Republic of Kenya.
Yes.
Njeri is protected under Article 1 on the sovereignty of the people. Njeri is protected under Article 10 on the public participation, values and principles of governance, the question of democracy, the question of participation of the people, equality before the law. Yes, Njeri is entitled because in Article 118, Parliament is supposed to involve the people of Kenya in legislative processes and any other act that Parliament engages in.
So Wakili, on that,
Yes.
the charge sheet, the first count,
Yes.
they said under unauthorized interference
Yes.
with a computer system, contrary to Section 16
Yes.
of the Computer Misuse and Cybercrimes Act, they say that, this according to the charge sheet, that Njeri created
Yes.
and deployed a web-based program
Yes.
that allowed now members of the public
Yes.
to send emails to the National Assembly.
Yes.
But the mass email in the charge sheet,
Yes.
they argue,
Yes.
it disrupted the normal functioning of the committee's systems.
Yes.
So the prosecution now is nailing her under unauthorized
Yes.
interference with the computer system.
Yes.
Because it ended up now jamming.
Yes. Remember, sorry, excuse me. Remember, that is a creation of the DPP. The law does not speak about the issue of jamming. The law speaks about interference.
Intention.
Yes, and interference, unauthorized interference.
Yes.
So the first test is, was she authorized to act in that manner? The answer is yes, but let me also read for you number 2, paragraph B. It amounts to interference if the person whose act causes the interference does not have consent to interfere from a person who is entitled. So there is also the question of consent. The fact that Parliament published this email, the fact that they invited the members of the public, and the fact that it is not the creation of Parliament to do it, but even the creation of the Constitution to allow people to publicly participate in the legislative processes, the Parliament has consented.
So is public participation in this case
Yes.
described? How do you participate? Can you send an email?
No, well, it is not, they have created various mechanisms and various platforms.
Yes.
One of the platforms is where they are telling us, send your memorandums to this email.
Yeah.
Therefore, when I send the memorandum to email and it crashes your system because of the inefficiency of your system, you cannot therefore say that I have interfered.
Because
And that's the case that I put forth.
Yeah.
I argued that case on that basis. I argued that case on the basis of Article 1, Article 10, and Article 118 of the Constitution.
Was there proof that the system jammed? Because in this count 1, where they say, as a result of what Njeri did, it led to mass email disrupting the normal
As to the question
functioning.
of proof, remember, proof can only come at the full hearing of the case, during the trial. That's when the prosecution will prove all their case. But now, because we never allowed it to go to that particular position, we do not know the evidence that the prosecution has in store for this case.
If that evidence is produced, will
Yes.
it change the case?
It cannot be produced on the basis of a charge that is not known in law, because the charge itself does not exist. The law does not require a person who has responded to a public invitation to be charged for conducting herself in a lawful manner as provided for by the law. And that's the difference about this case. And the unfortunate thing is that the regime is so intimidated by what was happening in the country that they are using this Cybercrime Act as a means of silencing us. Remember during the botched breakfast prayer in Safari Park, and they call it the botched because it was choreographed to that direction.
Wakili, okay.
You remember there was a priest who purportedly preached on a regime being apologetic. You remember this, somebody else came out to purport to apologize conditionally. Of course, that is Mr. Kasongo himself. Do I refer to him as Mr. Kasongo or Mr. William Ruto?
Oh, the president of
Mr. William Ruto
Kenya
purported to let me refer to him by his name. Mr. William Ruto purported to give a conditional apology. But before that, there was a very unique prayer that was made by the member of parliament for Dagoretti South.
North.
Dagoretti North.
Yes.
Honorable Elachi. That, oh God, help us to deal with the social media. That the social media is purporting to design the manner in which government will be formed. So this is a larger scheme of trying to silence and to control what people are fed with. Remember, previously they would easily control the mainstream media houses. They had the mechanism of controlling them previously. But now, any person holding a smartphone is a full media house. You can broadcast, you can make news that will change the course of this country. And therefore, they have realized that if they do not censor us, they do not censor these media systems. Remember, the mainstream media has a media council, there is all this. But as people owning phones, there is no regulatory mechanisms. So any person becomes a journalist, any person becomes a photographer, any person becomes an editor of the news. That is what they are trying to silence. But I want to them, because they cannot fight with data. Data is more powerful than an individual. Yeah.
Okay, so when we look at these issues,
Yes.
because there seem to be so many of them happening at the same time.
Yes.
The same law seems to just be a little bit ambiguous in terms of what should be allowed to happen or not.
Yes.
But is it stemming from the fact that citizens want to practice their sovereignty as individuals and then come together
Yes.
in a collective or concerted sovereignty?
That's correct.
To then be able to share information.
Yes.
How far does it go, really? Because we usually say that my rights end where yours begin. Do the rights of the people end where the law comes into place? Do we have that kind of relationship?
Yes, we have.
For people to understand, Wakili, and I think this is extremely important, because there are folks who have something to share. There are
Yes.
folks who are able to take information, break it down, and say, look, this is important, because that is one of the roles of government, to be involved in civic education for its people, to be able to understand.
May I
In
say
the
this?
event that doesn't happen, there are individuals who are gifted, and then would be able to break it down for people to understand.
May I say this?
Do the waters touch?
Government thrives in misinforming its citizens and making sure that their citizens are not aroused in terms of information. This is what is called the Napoleonic principle or ideology. Napoleon, when he captured France, he realized that the French people were so much civic and they were civilly awake. And of course, this stemmed from the French Revolution of 1776, when the French people overthrew the monarch, King Louis XVI.
Mm-hmm.
Why was King Louis XVI overthrown? He was overthrown because people were politically conscious, they were economically conscious, and they were socially conscious of their surroundings. So Napoleon realized this: if I allow this wheel of political consciousness, civil consciousness, economic consciousness to continue rolling, the same thing that befell King Louis XVI will also befall me. That is when he became president, when he became the king, he changed the system of education from being socio-oriented to science-oriented. And he said the Frenchmen will no longer deal with civic courses like CRE, like GHC, those who can remember, or social studies, anything that was awakening our consciousness. He said the French people will deal with mathematics and pure sciences, so that they may not revolutionize the mind of the French people. That is how government is able to control the civil awakening or the civil consciousness that is arising today. So, unfortunately, this government does not realize that the constitution that we gave unto ourselves has a concrete creed of freedom of expression. It does not understand that you have a concrete creed and we have a covenant with the people of Kenya. That the covenant is so sacrosanct and so sacred that the people of Kenya shall access information and shall express that information in the manner in which they so wish. Then we are told again by the same sacrosanct creed that in the event one is aggrieved by the statement that I make, you take the civil way of addressing it.
Yep.
You do not take the liberty of trying to silence me. And that's why we came all out on that day. Why were we all in court? And why shall we be in court again to defend any other person who is going to be arrested on this heinous and protracted fight against the freedom of expression? We are doing this because we want to tell our people that you have a freedom, you have the freedom of expression. And you should not be limited insofar as that exercise of the freedom does not infringe any person's right or freedoms. We came out so that we could demonstrate to all and sundry that we shall be out in defense of our constitution, and any person who wants to express himself should express himself in whatsoever manner that he or she wishes. And should the regime arrest you, be thou informed that we shall be there to defend you to our last drop, to our last man. So I'm giving them courage this morning that they should be out to express themselves. If you're discontented with the finance bill, express yourself through the media. Go out on the streets to express yourself. And you might want to ask yourself where I'm coming from.
And also to ask that these things that you're saying can be done, whether they fall within the law, because
they must they must fall within the law.
They must, or they do.
Whatever you do.
There's a different question here, Wakili. They do fall within the law, or they should fall within the law?
One, they fall within the law, and not just any other law. The Constitution itself, the supreme law of the land. And I'm also giving a caution that as and when you get out to express yourself within the confinement of the Constitution, make sure that you are doing what is lawful. For example, the exercise of Article 37, the right to picket, the right to demonstrate. Insofar as that you exercise that right to demonstrate within the confinement of the Constitution, you respect people's properties, you're not violent, you're working within this the defined code of conduct of demonstration. You are free to move to the streets even today. It is not a right that is guaranteed or given unto you by the state. It's an inherent right that is given to you by your maker and by your creator. And therefore the state should not and shall not determine when and how and where you shall exercise that right. And as I sum up, remember the alternative of Article 37 is to give the Kenyan people a leeway of exercising their sovereignty. Remember when I began, I told you that we have two systems or two mechanisms in which we can exercise our sovereignty. We can either exercise our sovereignty directly, where I, Ndegwa, go to the street to say I am opposed to the finance bill, or I can send a memorandum to Parliament through an email, where I'm telling Parliament, consider these views. But when you send a memorandum to Parliament, you are arrested. So what happens is that you are left to exercise your residual powers under Article 37. Because currently, the Article 37 has constitutionalized and institutionalized our streets. That is therefore to say that our streets is the other institutions where our voice can be heard from.
You see, when you talk about the cybercrime that is being alleged, I just want to quote what Kuria told members of the Republic on what they can do. And this is what he said, and I quote him: to ensure inclusive participation, please submit your views virtually via QR code that was given. And this time round, we committed to moving beyond the traditional model, which is people appearing in barazas.
Yes, yes.
And digital engagement will not only save time but also ensure more Kenyans can participate meaningfully. By the time the chairperson of finance committee was sending this communication, it was simply inviting Kenyans to send these emails and through QR codes and everything.
Absolutely.
So as you speak about the crime is not anchored in any law,
yes, yes,
then appears as though the only message that should be heard is yes, sir, we want
yes, sir, yes, and that's the unfortunate of this regime. A regime that is failed, a regime that has failed, a regime that is failing, a regime that cannot survive the will of the people behaves in this manner. Because we cannot be a yes, sir nation. We cannot be a yes, sir people. We are a people who are independent. We are a people who exercise our free consciousness to think and to do things in the manner as prescribed by the Constitution and by the law.
You know, there's so many interpretations, Wakili, and I know you have a question. Okay, just a minute. There's so many interpretations as to what can or cannot happen, right? And so here are the people. It's obvious that there's some kind of friction. There's something that's, you know, uncomfortable in the seat, as it were, and that folks feel that they need to then come out and either one, express themselves, number two, educate others, simplify things, so we can all be kind of on the same page. But then there would be this other voice that says, well, there needs to be an element of control that's applied when certain things happen. And I come back to that question. Do rights end? Does sovereignty end? Or is it something that continues to flow naturally? Does it end at some point where the governance bodies will be able to come in and say, well, actually, you know what? Yes, you are free, you have rights, but only
I love that question, Let me tell you, government is subservient to the people. Government is subordinate to the people. The people are above government because the people are the ones that confers government with the responsibility of executing functions, and that these functions are people-oriented. People do not create a government so that the government can become a monster. People create a government so that the government can in return be able to serve the people. And therefore, the government is subordinate to the people, and therefore the people are the sovereign, because it is the people who confers this power to government. That is to say that sovereignty has no end. Sovereignty is perpetual. Sovereignty flows like a river. It has a start. It starts when you are born and ends when the people, and does not end. As long as the people are in existence, sovereignty will always be supreme. And therefore, our people must understand this clearly, that a police officer is not above you. Mr. William Ruto is not above you. Mr. Kindiki is not above you. Neither the Chief Justice, nor the court, or any other person who is above me as an individual. Why? Because the constitutional design that we created, the constitutional architecture is that we have created a servanthood leadership. A servanthood leadership, that means that the governed becomes the servant. I, the people, becomes the master. And as soon as the people realizes this, they will not bow down to ask for services to be delivered. It is the responsibility of government to deliver these services. It's not a favor that the government is doing to us when we tell them we want to give our views in terms of this finance bill. And what will happen is this, Eric, Dennis. What will happen is, if you block the system of us forwarding your emails, our emails to you, if you arrest us for forwarding the email to you, we shall take to the streets, because you cannot silence our voices. So they should not think that they are going to use the court as a mechanisms, and the DPP and the police are the mechanisms of silencing us. But we shall opt for the next option of taking to the streets, so that we can shout from the streets for anybody who bothers to hear.
But then there's also this counter argument. you have these rights.
Yes.
You're within your constitutional rights and you have these freedoms.
Correct.
But so do other people. So
Yes, they do.
where do you then draw the line in terms of limits? So you can go to the streets.
Yes.
I want to drive to work. I want to open my business.
Yes.
But because I can't open my business or drive to work because you are on the streets
Yes.
and you're obstructing me from doing my business, am I also not then within my right?
You're right. Your argument is correct.
So where do we have these limits then? Because
What we are saying is, we are sensitizing our people. We are sensitizing our movement to make sure that they understand that when we take to the streets, we must not interfere with the next person who is operating his kiosk or his shop or who is driving to work. That person who has decided to drive to work, let him or her drive to work. That person who has decided to open his kiosk, let him or her open it without interference. And that's a civic education which you are giving to the people. And the moment we attain that threshold, nobody will come to tell you that you should not go to the streets. But unfortunately, we are dealing with a regime that is so apprehensive and a regime that fears the people. And that is a tragedy. The people put you in power, and then you become the enemy of the people. And that's the tragedy this country is facing. That the regime itself does not feel embraced by the people. Of course, going by what the people said yesterday, the other day, that they have lost 75% of the support of the people. In civilized democracies, a regime such as this one would hang the boots and go. But because we are being led by uncivilized men and women who have no courtesy of deciding when the people have withdrawn their support, when the people have withdrawn their supremacy, when the people have withdrawn their sovereignty, they cannot hang the boots. So if this was happening in a place like, say, the UK, today, Mr. William Ruto would be tendering his chicken in Sugoi, because he would have gone long time ago because he has lost the support of the people.
Degwa, my rights end where Okari's
That's correct.
begin, right? I want to bring this with regard to the cybercrime that Njeri are allegedly committed.
Yes.
Can the government say that my right to have a smooth system stops where you jam my system?
No, the government cannot be the
Seems like
nyapara.
that's what they're saying.
The government cannot be the nyapara of how I'm going to exercise a right that is inherent and given to me by God. The government cannot be the prefect. The government cannot be the policeman. The government cannot be the commander who tells me that I should not speak the manner in which I'm speaking. If you feel that I have offended you in the manner in which I'm speaking, if you feel that I should not tell Mr. William Ruto that you have lost confidence of the people and that you should resign because 75% of the Kenyans do not believe in you, what offense have I committed? And how has that infringed your right? As my neighbor, so as to say that I should not express myself in this manner because I'm offending you.
You're hurting my feelings.
Well, unfortunately, in matters governance, we are not dealing with emotions of love and affection. We are dealing with the manner and and a question of putting into place a government that is responsive to the people of Kenya.
It does seem as though what should set precedent and maybe also what should instill fear in people then is now playing against each other.
Yes.
That, and perhaps it's a tactic, not perhaps, that we've seen this, and not just
it's a tragedy by a weak and feeble regime.
And we've seen this, that the censoring of spreading of information or coming out and being very clear about is something that has been used for across the globe.
Yes.
And that flies in the face of constitutionalism and, just freedom of expression.
That's correct.
How can you then say that I want to be, because we call for it all the time, don't we? Democracy as an ideology calls for citizen-centered participation in governance.
That's correct.
It calls for that. How do you do that while remaining within the ambit of the law and at the same time being an informed and participating citizen? How do you do that when you see, okay, I could say something, but then I could very well not make it home tonight? I could say something and I could be also in jail for 4 days before then being presented to court.
Yes.
How then do you play with that very, very normal reality that's facing a lot of people today?
How to play about that issue is to make sure that a regime must understand and must accept that it will be criticized in the morning, lunchtime, and in the evening. Even in our dreams, we'll sleep criticizing a regime such as this one that is led by Mr. William Ruto. So the system must be responsive and must create some shock absorbers and be able to understand that the constitution has created two systems or two sides, the minority and the majority. For them who feels that they support the government, they have a right to support that government. And they have a right to support it without being intimidated.
Okay.
Me who feels, Ndegwa, that I cannot support this government, I cannot fathom supporting this government, I cannot dream or even imagine supporting this government, I too have that right. I have that freedom. The government should not perceive me as an enemy because I'm criticizing it. The government should not perceive me as an undesired character. And the government should be able to know that it is a democratic right that I'm exercising. But now we need to change the manner in which we think. And that's why I agree with Okari when he said we need to reset this country. Because the guys who are leading us, the software that they are using is a Pentium 2 software. Is a Pentium 2 software. They do not even understand. That's why a member of parliament will go and say, help us God to create, to control social media. And my question was, when you were starting to pray for social media, ulikuwa inataka iokoke, iende binguni, ama ulikuwa inataka ifanye nini? Because that is Pentium 2 ideology. Pentium 2 approach when we are speaking of the AI. You know? So, these guys who have these ideologies and the Pentium 2 thinking, we must get rid of them.
Wakili.
And not just getting rid of them, also supporting them with guys with which Pentium now is currently in Pentium what? We must be in Pentium 15 now. We shall support them with the Pentium 15 hard disks. Yes.
Okay, my question, I want to go back to the case of Njeri as a classic example of numerous arrests that we have seen. I'm referring to, the abductions, arrests, and all this, because you've been in all these cases, or most of them. Now, if the court, or as a lawyer, just explain it to me, if the court were to apply the law strictly and impartially based on how the arrests are made, detention circumstances, should this be the first considerations looking at the key violations and implications? Because we look at the rights of arrested persons in Kenya and Article 49 of the Constitution. In the case of Njeri, so you're presented to court, you have a charge sheet. Should then should the court then look at a summary of the violations first of this person that has been presented? Or how do these arguments go? Because I'm looking at, this is just an example, a precedent, just to put this into context, where a Kenyan court, MKO versus Attorney General, 2015, where illegal detention beyond 24 hours in that example was ruled unconstitutional, and therefore the court couldn't hear the case. But now we see classic examples of so many arrests in the case of Njeri. You go to court as lawyers. How should the court then demonstrate how it applies the law?
Let's understand that when is a detention considered to be an illegal detention? A detention is considered to be an illegal detention if it goes past 24 hours. The Constitution has created avenues, where if an arrest is done on a day when a person cannot be presented before the court, you'll be presented in the most available opportune when the courts are available. That is to say that from the time she was arrested on Friday up to the time she was taken to the court, that was not an illegal detention, to be honest. It was not an illegal detention.
From Friday to
the day she was
till Tuesday. Okay.
It was not an illegal detention because the state was careful enough to present her before court before the lapse of 24 hours. The mistake that occurred was the failure by the OCS to afford her bail or bond, noting that all offenses in this country are bailable, including murder, including treason, Even William Ruto himself was bailed when he was charged with an offense of crimes against humanity for the Kiambaa Church and others. He was also bailed because most of the offenses from the international law jurisprudence, they are now bailable.
Okay.
But now the question that Okari then should be asking is, when an OCS fails to grant you bail on such kind of an offense, should we just stop at that? When the law is so express that you should be granted bail? But when we went to the OCS on that particular day, on Friday and on Saturday, the OCS alleged that this is not I'm not the person who has remanded this person. The person has been remanded by the DCI. So they say, if you want Njeri to be released, go to the DCI. And that's a disconnect and the system within which this government is using to abuse office and power. So if today you are arrested, Dennis, and taken to Kamukonji police station by the DCI, it is presumed that the OCS in charge of Kamukonji police station has no power to release you on bail. Yet is a person who is in charge of that police station. So they are using those systems and cat and mouse ways of abusing their office and their power. What are we then saying? We are saying, if you are the OCS in charge of a particular police station, you must exercise your powers constitutionally. You must be able to understand that for whatsoever offense that one is alleged to have committed, and such as this one, which is ordinarily a misdemeanor, you must admit that person to bail. The DCI's power must be confined to investigations, but not to the administration of justice within a police station. That is to say, when we take over power and government, these officers who are behaving this irresponsibly, we shall put them to account.
Okay, before you take over power,
yes,
still on that line of thought, I don't want to lose it. So this person, so I've been arrested.
Yes.
I'm detained in some police station.
And don't postpone this idea of taking power for so long. I wrote it like yesterday.
So the whole bond bail thing. What about access to legal advice or to a lawyer?
Imagine it is a constitutional right, and not just a constitutional right. In the Constitution, we have the categories of rights. We have those rights that can be limited, we have those that cannot be limited. We call them derogable and non-derogable rights. A right that cannot be limited is a right to access to legal representation.
Okay.
That right cannot be limited. That OCS limited that right to Njeri. And that's why we are saying, when the rubber shall meet the road, at that particular point, that OCS shall be called to answer. Are you bigger than the Constitution? Are you larger than the Constitution? Mr. OCS in charge of Pangani, are you larger than the Constitution? Mr. OCS in charge of, or Mr. OCS in charge of police station of Pangani, are you bigger than the Constitution? Are you the one to determine when a right should be enjoyed or when should not be enjoyed?
On this OCS.
So that is to say, as we go to that OCS, Njeri has a recourse against that individual, that police officer alone, because she's the one who violated the Constitution. And therefore we are going to court and prosecute that OCS in or her own capacity without involving the state, because she is in charge of implementing and observing the authority of the Constitution at that level of the police station, so that when we are able to teach these officers and these OCS some manners and some lessons, that you must respect the Constitution, that any authority, be it the IG, be it the CS for Interior, be it Mr. William Ruto, they are all under the authority of this Constitution. No one is above this Constitution. Therefore, when you tell me that that is order from above, it's a nonsensical way of addressing that issue.
Because the Constitution
is above William Ruto.
All of this
is above the IG. The IG is subservient to the people. This IG is subordinate to the Constitution. So who is this who is larger than the Constitution?
That's a question for us to kind of end this particular conversation on, because if anything comes through here, that the Constitution ought to be that,
absolutely
board that you bounce all of this.
It is the cardinal north.
Yeah.
Yes.
That's the north you must face. Wakili Njeri Ndegwa has been our guest this hour. Our Justice Thursday conversation has been around an issue that's currently ongoing, but then pointing to issues in the legal and judicial world that we continue to put our eyes on.
Yes.
Your last words.
Yes, my last point is that there are those who are asking, who are calling people who are in the one-term movement tribal. Our argument is one. If you're able to mobilize the Kikuyus, mobilize the Kambas, mobilize the Luyas, mobilize the Luos, mobilize any tribe on the basis of that unit alone, with the objective of removing Mr. William Ruto from power, then that is positive mobilization and positive use of our ethnic strength.
And not tribal.
And not tribal. Number two,
quickly.
Any person, there are those who are asking who will be a presidential candidate. I am telling our supporters, that should not worry you. Any person who subscribes to the ideology and the philosophy of the one movement, one-term movement, is a potential presidential candidate. The only qualification is that you prescribe to the faith and the belief that Mr. William Ruto is a one-term president. Any person is potential, can be a presidential candidate, including Mr. Okari here, Duoko.
Maybe not me, but okay.
As long as you prescribe to that faith and that ideology and the philosophy of one movement, you are a potential presidential candidate.
Thank you so much for being on Justice Thursday today. Good morning, folks. 2 minutes past 9.
Dental Tips brought to you by Sensodyne, the gentle touch.